My name is Leila Amineddoleh, and I am editor-in-chief of the Albany Law Journal of Science and Technology. Welcome to this year's symposium titled Cultural Patrimony, Art Markets, and Human Rights. The Albany Law Journal of Science and Technology is one of the oldest and most established science and technology journals in the country. The journal is ranked 21st in the nation in the categories of science, technology, and computing. This journal gives life to cutting-edge scholarship, including pieces on artificial intelligence and dispute resolution, facial recognition technology, and Fourth Amendment issues, and cybersecurity and evidentiary issues. In short, the scholarship that we publish meaningfully contributes to the discourse regarding the intersection of science, technology, and the law. This symposium will broaden our perspective on the connection between cultural heritage and international law, commercial law, human rights, and many more. I learned a lot from meeting with these panelists in preparation for this symposium, and I'm confident that you all will too. Now, it is my pleasure to introduce you to the person responsible for this symposium today. Daniela O is the symposium editor for the journal. She planned this event starting way back when she was appointed in March of last year, and she was able to find a diverse and esteemed panel for today's discussion. This symposium is the culmination of her hard work, diligence, and commitment to bringing light to the issues we will discuss today. Before turning it over to Daniela to tell us more about the topic and the speakers, I want to thank all who helped to plan this event, including our faculty advisor, Professor Heverly, our moderator, Professor Rosenbloom, the faculty and staff of this law school, and most importantly, the panelists that are joining us today. I also want to thank all of you for being here today. You're in for a treat. Thank you.
Thank you again for coming. It means a lot to our journal. The symposium is inspired by my stay in Belgium. I had to work for a law firm in Brussels last semester. While I was grateful for having such an enriching experience of visiting UNESCO World Heritage Sites and art museums, I was aware that in some parts of the world, cultural heritage is destroyed by armed forces, natural disasters, and lack of maintenance. It occurred to me that our next generation won't be able to enjoy cultural heritage sites if we do not take actions to protect them. What law school has taught me is that law protects something we appreciate. Therefore, the more we understand the value of a cultural heritage, we will apply our minds to protect them. Cultural heritage connects us to the past and future. It represents our shared values, emotions, and collective memories. Also, cultural heritage sites and art drive the tourism industry. Artists play also a vital role in shaping and leading an innovative economy with their creativity. They are defenders of democratic values. Nevertheless, cultural heritage law is complex and multidimensional. During my research, I was surprised to find out that proceeds of stolen artifacts are used as a means to finance terrorist organizations. It is easy to think that cultural heritage law is a niche field of law. In fact, Manhattan DA is the only place in the world with a special law enforcement task force to investigate antiquities trafficking. It is my hope that the symposium will open up meaningful dialogues to protect artists and cultural heritage. Without any further ado, I would like to introduce our moderator, Professor Rosenbloom. Professor Rosenbloom obtained Bachelor of Fine Arts and Bachelor of Architecture from Rhode Island School of Design. He received his Juris Doctor from New York Law School, LLM from Harvard Law School. At Albany Law, he provides courses on property, climate change, and land use. He authored several books on resilience and sustainability. Not only is he one of the top 200 ranked scholars on Heinel Line, his scholarship has been cited in over 150 federal opinions. On a final note, and more importantly, he truly appreciates arts and film. In many ways, he's an artist himself, given that he's a theater actor himself. Please welcome Professor Rosenbloom.
Thank you, Daniela. Definitely an overstatement in terms of what I do on stage. But good afternoon, everyone, and welcome to what should be a fantastic series of discussions and panelists on cultural patrimony, art markets, and human rights. Daniela, Natalie, and the entire general staff have put together a fantastic group of scholars and artists to help us explore the richness of cultural patrimony and its overlap with the law. So join me as we explore why cultural heritage and arts matter, how they can help build peace, where they overlap with the law, what the law is, what its role is rather in cultural patrimony, what lawyers' role should be is in creating and protecting creativity, and why we should celebrate cultural patrimony and the diversity of traditions and artistic expressions to preserve the past and inspire future generations. We'll explore these questions through a combination of discussions and insightful presentations. We'll have two panels. The first panel will really set a foundation. Then we'll have a series of questions. And then we'll move to the second panel where we'll dive into more specific issues concerning some of the cultural patrimony and art markets. So let's dive right in with our first panel, which is going to consist of Leila Amineddoleh, Hilary Hoffmann, and Lauren Van Schilfgaarde. We're very fortunate to have Leila kicking things off here for us today. She's an internationally recognized expert on art, cultural heritage, and art crime law. She is the founder of her named firms. Her clients include prominent art collectors, museums, galleries, and government bodies, including the New York District Attorney's Office of Antiquity Trafficking Unit and the Eastern District of New York. She has handled numerous complex disputes and authentication issues, including high-profile repatriation cases. Several of the examples, or many of the examples that she has worked on in terms of repatriation include art, culture that could easily fill a world-class museum and include things like mummies that were returned to Egypt, a rare 4th century BCE marble bull's head from Libya, a mosaic belonging to Caligula, and many others. After Leila, we'll have the pleasure of hearing from Hilary Hoffmann, co-director of the Beers Ears Coalition. Prior to her work with Beers Ears, Hilary was an internationally known law professor and expert on indigenous environmental governance. She's the author of a fantastic book, which if you haven't read it, I highly recommend it. It's called The Third Way: Decolonizing the Laws of Indigenous Culture, Cultural Protection. She has also authored numerous articles on indigenous rights. I very much look forward to your presentation, Hilary. And then our final speaker on the first panel is Lauren Van Schilfgaarde, who will join us via Zoom. Lauren is an assistant professor at UCLA Law. Her research focuses on tribal sovereignty and federal Indian law. Her recently published article, Restorative Justice as Regenerative Tribal Jurisdiction in the California Law Review, is available on SSRN, and I also highly recommend this piece as well. Lauren previously served as the tribal law specialist at the Tribal Law and Policy Institute in West Hollywood, California, focusing on restorative justice and tribal court infrastructure. With that, please join me in welcoming our first panelist, Leila Amineddoleh.
All right. Got it. Thank you to Albany Law School and to the Albany Law Journal of Science and Technology for inviting me to present this afternoon. Can you all hear me? All right. I was given the formidable task of introducing the topic of cultural heritage law in 12 minutes or less. So here goes. What regulates the trade of art and antiquities, both national and international law? One central tenet of art law is that the protection of objects for present and future generations. The specialized treatment of heritage dates back millennia. In the 1st century BC, Cicero prosecuted the Roman general of Sicily, Gaius Varus, for plundering cultural objects while ruling the island. During trial, Varus pled no contest and voluntarily went into exile. Sadly, though, history is full of leaders who lusted after art and culture. One well-known example is Napoleon, who attempted to create a new Rome in Paris by looting across Europe and North Africa. Unfortunately, I don't have sufficient time to address centuries of looting, including Nazi looting and colonial era takings, and changes in the way that museums, communities handle objects taken under violent circumstances. That will be a discussion for another time. People in the ancient world were so concerned about looting that some attempted to ward off plunderers by placing curses on their property. Perhaps the most famous was the curse of the pharaohs, an alleged curse believed to be cast upon any person who disturbs a mummy, the mummy of an ancient Egyptian, especially a noble one. Sadly, though, those curses did not deter plunderers. Rather, modern jurisprudence has proven more effective, although still not foolproof. In fact, individual nations have fought to combat looting for centuries. During the second half of the 20th century, there was a growing recognition that cultural losses weren't just the result of destruction, but also caused by looting. And thus efforts were made around the world to curb the illicit trafficking of heritage. The most significant convention aimed at reducing plunder is the 1970 UNESCO Convention. Signed by 143 state parties, it signaled that nations were cooperating to protect heritage. It defined preventative measures state parties should take, and it binds signatories to take those steps to recover and return illicitly removed property. But actually, 1970 doesn't have the legal significance it's often awarded. Art market participants often incorrectly refer to 1970 as a type of cutoff date for the acquisition of antiquities, meaning that they believe there's a blanket rule that allows artifacts with a provenance being an ownership history dating back prior to 1970. And they believe that if they have this provenance, that they can trade these works legally. That's actually not true, because some nations have heritage laws predating 1970 by decades or even centuries. The laws used to protect antiquities and recover stolen property are referred to as patrimony laws. These laws vest ownership in nations for all undiscovered antiquities from within their borders. Cultural objects are declared state-owned, and many not to be, and most of these laws, many of these laws indicate that these works cannot be privately sold, owned, or exported absent express permission. These laws often also impose civil and/or criminal penalties on those who violate them. Importantly, other nations enforce these patrimony laws. U.S. courts have recognized foreign patrimony laws since the 1970s, holding that property taken in violation of these laws are considered stolen, the principle referred to as the McLean Doctrine, after a case, U.S. versus McLean. In that case, the National Stolen Property Act was used to prosecute U.S. citizens for trafficking in pre-Columbian artifacts. The courts considered whether in 1972 Mexican law created sufficient ownership rights for objects removed after 1972. The court found that it did, and that Mexico owned the artifacts even if it never actually possessed them or even knew of their existence. One of the most famous cases following the McLean Doctrine led to the imprisonment of a well-known New York antiquities dealer. Fred Schultz was indicted for his part in an audacious scheme. He worked with Jonathan Tocqueville Parry, a British tomb raider who smuggled antiquities out of Egypt. Tocqueville Parry is a self-proclaimed antiquities restorer known for smuggling over 3,000 pieces out of Egypt. He supplied Schultz with objects by disguising them as cheap souvenirs that he purchased in bazaars, and he created false provenances by inventing a fictional collection predating Egypt's patrimony law. In 2001, Schultz was indicted under the National Stolen Property Act. The export of the looted antiquities was in contravention of Egypt's patrimony law. Schultz was sentenced to 33 months of imprisonment and paid a fine of $50,000, which is actually kind of small if you considered all the works that were damaged and exported illegally. One recent litigation demonstrates the difficulties of litigating an ownership claim, and that case is Turkey versus Christie's. This case is also very significant in how the court considered patrimony laws. Known as the Gwenyl Stargazer, this 3rd millennium BC artifact was the cover lot of Christie's exceptional sale in April 2017. It's one of only 15 known examples of sculptures, complete sculptures of this kind. The item was expected to fetch $3 million, but it sold to an anonymous bidder for $12.7 million plus premium. The Gwenyl Stargazer was part of a private collection, which was exhibited at the Metropolitan Museum of Art numerous times between 1967 and 2017. It was acquired by Alistair Martin and his wife in 1961 or prior. 1961 is the earliest date for which there's actual provenance information. It was passed down through the family, and in 1993, a gallery acquired it and then sold it to notorious collector Michael Steinhardt, who unfortunately we don't really have much time to talk about today, unless his name comes up in questions. So that same year, Michael Steinhardt consigned the idol to Christie's. When Turkey learned of the Stargazer's sale, the country contacted Christie's to halt it. According to Turkey, it was only through viewing that auction catalog that it learned that the idol was initially sold by a man named J.J. Kledgman, a dealer known to trade in smuggled artifacts. In fact, former director Thomas Hoving of the Met stated that Kledgman was one of his favorite dealer smugglers. And it didn't really matter that the Stargazer had a pre-1970 provenance. It was still susceptible to an ownership claim. So Turkey sued Christie's. To sue for repatriation, Turkey needed to prove that it had an ownership claim. How can we do it? By proving that there was a relevant patrimony law. Here, Turkey argued that a 1906 Ottoman decree was relevant. And in a decision that surprised many, the court interpreted Turkey's patrimony law very broadly, holding that a 1906 decree on antiquities applied, even though that law existed prior to the establishment of modern-day Turkey in 1923. And for those of us who work with patrimony laws and study this area, that was a really surprising holding by the court. This type of holding had never been made in the past, that a court had recognized a patrimony law predating the existence of a modern country. But even though the court found that the Ottoman decree applied, the work still didn't go back to Turkey. The court still could not conclude that the idol was excavated from Turkey after 1906, both prerequisites to finding an ownership claim, to finding ownership under the law. Also, as a side note, the court found that even if Turkey had established ownership rights, it had slept on its rights by waiting too long to file a lawsuit. Turkey could not provide specific evidence about the find spot and removal date because the Stargazer was likely looted. And the court found that the Stargazer could have left Turkey in ancient times or at any time prior to 1906. Turkey appealed and the Second Circuit Court affirmed. But Turkey's predicament is common amongst nations claiming restitution because most looted antiquities lack provenance. Thieves generally don't maintain records of their crimes. Talk about two cases. I wish I could talk about a million, but just don't have enough time. The Persian Guard relief was part of a procession of figures and persepolis photographed by the University of Chicago during an excavation in the 1930s. One morning, archaeologists returned to the site to discover that someone hacked the relief off the wall. Authorities were alerted and the Iranian government attempted to recover the piece, but it disappeared on the black market. Unbeknownst to everyone involved, it was sold to a Canadian museum in the 1950s and then was stolen again decades later. But it was eventually recovered and put up for sale by a gallery. The Guard appeared for sale by the Rupert Wace Gallery, a British gallery, for $1.2 million at an art fair in New York in the fall of 2017. Fortunately, in October 2017, Dr. Lindsay Allen from King's College in London saw an ad for the fair on Instagram, and she recognized from this photo, she recognized the piece because of the damage in the spear and on the crown. So she realized it was the work that had gone missing almost 100 years prior. She actually contacted me about the piece, and I informed the authorities, the Manhattan District Attorney's Office, about the looted property. And I had the honor of consulting with the DA on this matter. Iran passed its first patrimony law in 1930. And we know from extensive records that the relief was stolen after 1930 because it was recorded in situ in its site in 1935 and reported that same year. Iran owned the relief and it was subject to national regulations. Therefore, there was no possible way that title could have passed from the thief to another party without permission from the cultural ministry. A thief cannot transfer title, and so any subsequent purchaser could not gain title, and ownership remained with Iran. The Persian Guard was returned home to in September of 2018. We're not really discussing this, but it's also really interesting to see how people reacted to restitution to a country like Iran, where the US doesn't have diplomatic relations with Iran. And the reason it was able to be returned is that it was returned from the district attorney's office and not from the federal government of the United States. So I wanted to end my presentation with a more kind of positive example, and that it doesn't involve litigation or prosecution, but rather it shows that negotiations are also effective. One of the best known heritage disputes involved Italy and the Metropolitan Museum of Art. After the Met had acquired the famed euphonious crater for $1 million in 1972, at the time, the most valuable acquisition of an antiquity, at least publicly known, the Italian authorities demanded that it be returned. They thought it was looted and recently removed from Italy. The Met denied this and refused to provide provenance information or any information about the seller. Decades later, and if you're interested in this case, there's a wonderful book about it called The Medici Conspiracy that outlines the investigation by Italian authorities and reveals information about these looting networks and tomb raiders. But it was through this international investigation that voluminous photos and documents revealed an extensive network of tomb raiders and crooked dealers selling Italian objects. Tomb raiders throughout Italy would remove objects, often damaging them in the process. They would sell the pieces to middlemen until the objects made their way onto the international market and sold for hundreds of thousands or millions of dollars. The documents revealed that the crater was stolen from an Etruscan tomb in 1970. Unfortunately, it may have even been intentionally broken into pieces to more easily export this object from Italy. And the object is incredibly rare. So it's devastating that that's one of the effects of looting and tomb raiding, that these objects get destroyed. The evidence shows that all of these things happened after the passage of the Patrimony law, meaning that the country could demand repatriation. Once the Italian authorities had evidence that it was looted from within Italy's borders, after the passage of Italy's Patrimony law, Italy made a very compelling demand for repatriation. Italy and the Met signed an agreement under which the euphonious crater and several other archaeological objects were returned to Italy in 2008 in exchange for long-term loans of comparable objects from Italy. Some nations have had legal instruments to battle looting and demand repatriation for decades or even centuries. Today, those legal tools can be used along with negotiation tactics that incorporate ethical considerations, something I believe my fellow panelists will address today. Thank you.
Everyone. It's so nice to be here. This is a beautiful new courtroom that you have, and thank you all. Thank you to the Journal, to Daniela for inviting me here. Thank you to Professor Rosenbloom for the wonderful introduction. And if I can figure out how to. Okay, so I've titled this presentation Cultural Patrimony and Collaborative Management, and then focus in on the Bears Ears National Monument because that's where the bulk of my work is right now. And just by a show of hands, I wanted to see how many of you have heard about the Bears Ears National Monument before today? Okay, so a few of you. That's what I was guessing. I was guessing that probably a few of you would have heard of it and that a lot of you might not have heard of it. So I have some slides that kind of introduce the setting, the backdrop, and then I'll talk a little bit about the Antiquities Act, which is the statute that sort of gave rise to this national monument, which is kind of a living collection of cultural patrimony for 5 sovereign tribes in the Southwest. Oh, whoops, and I should talk about the buttes that you can see on this slide are the ears of the bear. And in all of the languages of the tribes that I work with, the place is referred to by that same name. So that's how the Bears Ears National Monument got its name, is because these 2 buttes that are located really centrally in the monument resemble bears' ears. Okay, so what is Bears Ears National Monument? As I said, it's a living national monument, kind of like a living museum, if you want to think about it that way, but with more possibly animistic qualities. It protects the ancestral lands and the cultural heritage of coalition tribes, and those are historical connections, but also present day cultural connections with these coalition tribes. And the tribes are the Hopi tribe, the Navajo Nation, the Ute Mountain Ute tribe, the Ute Indian tribe of the Uinta and Ouray Reservation. So those would be some of there were originally 7 bands of Ute tribes that lived in what's now Colorado and Utah. And the Ute Mountain Ute tribe is, those were sort of the southern bands. And then the Ute Indian tribe consists of 3 of the northern bands of Ute Indians. And then the Zuni tribe, as it's formally recognized, or you might also hear this nation referred to as the Pueblo of Zuni. So the monument is 1.36 million acres in total. So it currently is the largest cultural landscape of its kind in the United States. It's technically, I usually say it's federal land, but I have to say that it is mostly federal land and that it also has some sections of state land within the monument. So it was hoped until recently that those state sections might be traded out and the entire monument would be federal land managed by the 2 federal agencies, the Forest Service and the Bureau of Land Management, together with the Bears Ears Commission that I'll talk about in a minute. But that land exchange actually recently fell through. And so there are still 130,000 acres of state lands located inside the monument. There are estimated to be 100,000 ancestral dwelling sites. So those would be sites that Western archaeologists would refer to as archaeological sites. And so those sites would contain the objects of cultural patrimony that my fellow panelist was just referring to, but also burial locations and the remains of ancestral dwellings. So those would be sometimes referred to as ruins, but the way that our tribes refer to those places is ancestral dwelling sites. And this is just an estimate. So to date, the monument has never been surveyed comprehensively. So this is just based on modeling that the agencies have done based on known archaeological sites that exist and have been documented. But according to the tribes, there could be 3 times that in the monument. There are over 300 individual culturally significant objects. So in Bears Ears, cultural patrimony really has a more expansive definition than it might under federal law or under international law. So that was one of the first kind of, like, I don't want to throw wrenches into the symposium in the second presentation, but the way that the tribes that I work with would define cultural patrimony would be much broader than federal law or international law might recognize. And so for these tribes, culturally significant plants that would be used in ceremonies, like wild tobacco or wild onions, sage, those types of plants would be considered to be cultural heritage of these tribes, even though outside entities, the state and the federal government legally would refer to those as objects protected by the Antiquities Act or as natural resources. Okay, so where is Bears? So I like to use this map. This is the region to the native eye, which was done by, I believe, a Zuni cartographer, Stephanie Smith. And so you can see on this map how the monument is in green and it's centrally located between the modern reservations of the 5 tribes that I just mentioned. So Navajo Nation directly to the south, and that's the largest Indian reservation in the United States. The Northern Ute, the Uinta and Ouray Ute, that's the 4th largest Indian reservation in the United States. That's about 4 million acres. And then Ute Mountain Ute is just to the east. Hopi Reservation is located inside the Navajo Reservation, and then you can see the Pueblo moving down to the southeast. So the National Monument is the ancestral homeland of all of these tribes, but over the course of history and of colonization by the United States federal government, these tribes have been removed and essentially relegated to their modern day homelands, which are at a significant distance from the monument. So when we're talking about like repatriation, for example, bringing things back to Bears Ears that have been taken, it's a real quandary for us in my everyday work. Where do those things go? Should they go to the monument? There's no visitor center right now. There's no museum. Should they go back into these sites that as of yet are not protected? They're not fenced off from visitors and they're not protected from further looting, or should they go back to the tribe that can establish affiliation in their modern reservation, which might be at a really distant location from where the object was originally located. So the boundaries are within the modern state of Utah, but the tribes don't necessarily recognize Bears Ears as being within Utah. So I like to show this map because this map shows the location of the monument without respect to state lines. But if you're looking for state lines, just to give you an orientation to where it's located, it's really close to the Four Corners region, which is where Utah, Colorado, Arizona, and Mexico meet. So you can see that cross down on the bottom, which is the Four Corners. And then it's about 100 miles from that Four Corners monument up to the town of Bluff, which is the southeastern entrance to the monument. Okay, so I kind of covered this already, but I wanted to ask this question because I think this is a question that this symposium is exploring, and the answer might depend on the expert that you talk to. It might depend on the legal system that applies. So to lawyers, especially maybe lawyers who practice in federal court or in state court, cultural patrimony would be a term of art that would have legal significance, and there would be things, belongings, items that would fit within that definition or not fit within that definition. So as future lawyers, you would need to be careful if you're practicing in that area to make sure that whatever the item is that maybe an Indian tribe brings to you, that you would verify that it either fits or doesn't fit within one of the frameworks that we're discussing today. But to the tribal subject matter experts that I work with on a weekly basis, this term would be one of many terms that they might use, and they would probably refer to their cultural belongings using different terminology. So objects of cultural patrimony might be referred to, as they are for some of our tribes, as tangible links in a narrative that connects them with landscapes from which they came or which they passed through, and supernatural beings throughout time. So these items might be intertwined with what's called traditional indigenous knowledge, or the stories of the life ways of the ancestors of the tribal members that I work with today. They could be, the tribes that I work with have what's called animistic interpretations or epistemologies. So sometimes, an object that would maybe be to me innate and not imbued with these characteristics might actually be alive and have the qualities of a supernatural being, or it might have a role that it plays in a religious ceremony or story. And they can also be literal vehicles for healing past traumas. So the traumas of colonization, of genocide, of cultural theft and damage and destruction, of removal for tribes. So a lot of tribes were removed historically from their homelands and relocated to a different location. And some of these, I mentioned this because I think it's really significant, and I see it when we go into the monument with our cultural experts. I can see them talking about that, and I can see them talking about the meaning of some of the things that we see. And it's so clear that they want to show them to the young people. Like if we have young people with us, they want to show these objects to the young people and explain their significance as part of you know, making sure that the young people understand those cultural ties and understand that like, that coming to this place and seeing this object in this place is a sort of like, it's the world being in right relation with the people, as opposed to in the past when there have been historical traumas, those would be the wrong relation between people and place and objects. Okay, so I told you I was gonna look at the time. When did I start? Okay. So I wanted to talk a little bit about collaborative management also, because that is a buzzword. So I started out as a natural resources and environmental lawyer. And I also want to mention that to you all, because I think you can find your way to this field in a number of different ways. And that's the way that I came to it was, especially from my natural resources background, was constantly coming up against tribal treaty rights, tribal cultural interpretations of what I might refer to in the past as natural resources or objects of antiquity under the Antiquities Act. And so collaborative management is this buzzword right now in environmental law and natural resources law. And so I wanted to mention it because it's one of the reasons that Bears Ears is really well known in those fields. So collaborative management came about in the Bears Ears National Monument because of the Antiquities Act. And so the Antiquities Act gives presidents the authority to declare by public proclamation that an area of federal land is a national monument, as long as in the president's estimation, there are objects of scenic, scientific, or historic interest that are located on the lands that will become the national monument. It's a really broad delegation, almost to the point where some courts have held that it is not it's not subject to judicial review because the authority that Congress has delegated to the president is so expansive. And when President Obama originally established the Bears Ears National Monument in 2016 at the request of these 5 tribes that I work for, they requested that a tribal commission be established to provide tribal expertise and guidance to the federal agencies that would manage the monument to ensure that it was managed in a way that protected their cultural heritage according to their values. So President Obama did in fact do that. Within a year of President Obama creating the national monument, President Trump decided to reestablish it or destroy it, as the tribes might say, by issuing another presidential proclamation to overlay President Obama's proclamation and reduce the monument by 85%, and then subordinate the role of the Bears Ears Commission by inserting some state and local officials onto the Bears Ears Commission to essentially dilute the tribal expertise. And then in 2021, President Biden restored the monument to the original size of President Obama's monument, plus an additional 12,000 acres, and restored the Bears Ears Commission and created it again as an entirely tribal advisory body. So the Antiquities Act created a vehicle essentially for Presidents Obama and Biden to establish this new type of governance framework on public lands called collaborative management. And that's basically what it is it's tribal leaders, tribal cultural experts having a seat at the table and being able to advise how decisions should be made to protect objects of cultural patrimony and to protect the land where those objects continue to reside. So here's some photos of the monument. It's an incredibly beautiful place. I would advise you to go there. It is not like a national park at all. It's very remote. It's very rural. There's not a lot of law enforcement. So you have a lot of freedom there to go and hike. Currently, you can actually hike and go inside ancestral dwelling sites, even though the tribes that I work with would say that's a big no-no and you're not supposed to do that. But that's one of the things that they're working on is trying to educate visitors more and trying to get more signs and more fences and things like that kind of steer visitors so that they don't end up causing damage or harm to objects of cultural patrimony and the land itself without realizing it. These are the Bears Ears commissioners. I just wanted to show you their smiling faces. I love working with them. They all care deeply about ensuring that Bears Ears is a success so that other tribes can follow in the model of these tribes in Bears Ears and that they can have more of a role in directing how their sacred lands are managed. And I wanted to show you what collaborative management looks like. It looks like us going out in the monument a lot with cultural advisors and experts. They pick things up, they talk about them, they put them back down. They talk to each other in their own languages about how things should be taken care of. And then they'll translate that for us. And so another challenge that we have, in addition to the layers of federal law and state law, and then sometimes tribal law, is a language issue. And so what we get often in terms of direction to inform the land management planning process is translated advice that's been curated by the cultural experts and is capable of being shared with people like me who are outsiders. So there are a lot of internal rules and norms that guide these cultural advisors as far as what they can share within their tribe and sometimes within their own clan, and then with outsiders like me. So that poses somewhat of a challenge, I think, to collaborative management sometimes, but I think it's absolutely amazing that the work that's being done in Bears Ears is being done in the languages that have been spoken in this place, in some cases for up to 10,000 years. Here they are. This is a photo. Am I still okay on time? Ish. Okay. I just wanted to show you, for any who know the history of Hopi and Navajo, there's been a long schism between those two tribes because of the location of the Hopi reservation inside the Navajo Nation. And it's caused a lot of friction between those tribes. And here we have our Navajo Nation commissioner on the left with the bandana, Mr. Curtis Yanito, and then the Hopi vice chairman, Craig Andrews, on the right. They are the best of buddies on the Bears Ears Commission. They love flying around in the little Cessna, doing overflights. And they often are in complete agreement as far as decisions that the commission makes about how to protect certain sites, about how to advise visitors. So I think this experience has been restorative for these tribes in other ways besides, the direct impacts of colonization, but also just those historical wounds that have existed sometimes between tribes. This has been a healing experience for them. Okay, I won't go through these recommendations in detail, but maybe I can share, will we be able to share the slides with the audience afterwards? Okay, yeah, so you can review those on your own time. I wanted to show you, this is sometimes what will come out of some of our collaborative management meetings, where we'll talk to the cultural experts about how they want us to advise the federal agencies in the land management plan. And what will come out of those discussions is a picture. It would be like, outsiders might call it artwork or something like that, but it's actually like a visual image of what they want us to do, rather than a list, a bulleted list, like I'm really comfortable with. I'm like, okay, give me my headings and my bullets. I'm a lawyer. That's how I like to understand things and organize them. And what will emerge from our meetings is often much more visually oriented, and it will always show this interconnectedness between objects, items, plants, animals, the sky, the earth, time and space. So it's really interesting and amazing work. And I'll wrap up there and just say that I'm happy to take questions later on about Bears Ears, and also I'm happy to try to situate Bears Ears a little bit more in the panoply of federal laws that relate to antiquities and cultural patrimony if folks are interested during the Q&A. So thank you.
Thank you, Hillary. Lauren, can you hear us okay?
Yes, I can.
Okay, the floor is yours.
I assume you can hear me okay?
Yes.
Awesome. Hi, I'm Lauren Van Schilfgaarde. I am so sorry that I can't be there in person, but I am so pleased to be here with you virtually. I am a tribal member of Cochiti Pueblo, and so neighborhood of Bears Ears. I was very excited to hear more about the Bears Ears Coalition. It's a very big deal in my circles, and so pleased to see that it is being featured as part of this symposium. I am an assistant professor at UCLA School of Law, and so calling from Burbank, California, traditional homelands of the Fernandino Tataviam and the Gabrielino Tongva. Okay, so I guess I'm going to zoom out a little bit and discuss a little bit about how tribal cultural heritage gets protection, recognition under American cultural heritage laws. And in some ways, yes, and in some ways, no. I would note first, so I just went about 12 minutes. Is that what I heard?
Perfect.
Awesome. Okay, I want to be respectful of the time, so I'll try and aim to do that. So my argument is essentially that it is not a coincidence that we think about American cultural heritage law and tribal cultural heritage law distinctly, that they don't necessarily mean the same thing. And that is reflected in American cultural heritage law, at least up until recently. Ms. Hoffmann talked a little bit about the Antiquities Act, which I think is definitely part of like the toolbox that has been incredibly powerful and beneficial, but it's not a new act, right? It was passed way back in 1906. It's only recently become increasingly leveraged for the benefit of tribes. And in part, that's because tribes themselves have become a lot more politically participatory and maybe aggressive is not the correct word, but certainly present and pushy in asserting their rights for tribal cultural heritage protection. Another big example is the National Historic Preservation Act, which famously includes the Section 106 process, providing a statutory right to tribal consultation regarding traditional cultural properties located on federal lands. This has proven to be a big fat deal for tribes, providing a really substantive statutory pathway towards providing protection for tribal cultural heritage located off of tribal lands. The scope, of course, is limited to federal lands, though. California is an example of a place where we have domesticated the Section 106 process into state law, specifically the California Environmental Quality Act and what's like known as the AB 52 process, but same idea. These have all been really effective, but none of them were enacted with tribes in mind. It's after the fact that tribes have been like, ooh, like this is something that we can work with. We've had agencies like the Advisory Council to the National Historic Preservation Act that have been really proactive in helping tribes leverage this, crafting the National Bulletin number 38, right? These like numbers that don't even have names that recognize traditional cultural properties as another legal term of art recognized under the Section 106 process. But again, it feels like we're cobbling things after the fact. And we heard a little bit about the terminology of colonialism. I think that is relevant here in part for why we see the distinction. But I think it's important to note that colonialism is a little bit different than settler colonialism, at least from an infrastructure type standpoint. The premise of colonialism is to go to a place and extract resources for the benefit of like the primary colonizer. Settler colonialism is not necessarily exclusively about extracting, but staying, and staying for the purpose of replacing the polity. And so where colonization really prioritizes extraction, settler colonialism prioritizes erasure. It is critical to clean the slate to make space for the new polity. And this, I think, is certainly reflected in the Indigenous experience, where Indigenous labor was not prioritized, but rather people needed to be moved notably west and then shrunken onto reservations with the idea that eventually Native people would disappear. As this disappearance is feeling increasingly inevitable, especially at the end of the 19th century, early 20th, we get a rise of policies aimed at expediting that process, coupled with a renewed, not new, but renewed fascination, almost fetishizing of Native cultural property. It becomes bougie, right, to have access to all of these in a way in which there is a market that is specifically geared towards, quote, Native cultural property. Now, this is happening contemporaneous to Indigenous peoples crafting their own marketplace, producing wares, potteries, jewelry, rugs that are specifically intended for public consumption for a commercial marketplace. The Indian Arts and Craft Act, a consumer protection law, is reflective of this. But the market, certainly at the end of the 19th century, but also true today, does not necessarily prioritize those products that are intended for public consumption. Rather, there is a hunger for what is perceived to be not intended for public consumption, but is imbued with something special, something that's supposed to be private, but has some mystical quality that gestures to the overall American fetishizing of Native people as distinctly other, vanishing. Some cling to authentic Americanism and yet also inferior. So that brings me to sort of like my primary point. We have this arc of cultural heritage laws that have always perceived American cultural heritage as different, right? Beginning at the earliest, at the point of European contact. So American cultural heritage laws generally prioritize European influence and the extent to which the culture started when Europeans came here. But as Native people didn't vanish and have started to exert their political force, we get things like the Bears Ears Coalition, right? Tribes inserting themselves as active participants in this co-management. Even a palette for the idea of co-management is relatively new. We get some express laws in federal law that recognize tribal cultural heritage as such, the most notable being the Native American Graves Protection and Repatriation Act of 1990, finally extending parity to the dignity of human cemeteries and grave sites and human remains that like just treat us like you do other grave sites, like don't mess with it unless you have consent. But still, like the going is slow. And so the 1970 UNESCO Convention was mentioned. This was a particular moment in part because it recognized a global consensus and a pathway to develop bilateral agreements between nation states to facilitate the repatriation. But in order to take advantage of the 1970 UNESCO Convention, a country has to claim a certain product, site, artifact, piece of cultural patrimony as its own to protect the human remains of the ancient Egyptians. Egypt has to claim that as its own. The United States has 26 bilateral agreements with other countries and has helped to facilitate the repatriation of things that have been improperly brought into the United States back to those 26 nation states. But the United States has never claimed indigenous cultural patrimony as its own. And that's a problem because there are native cultural patrimony all over the world, including inappropriately, including specifically in Parisian auction houses, in which the tribes have been advocating for their return, but the United States can't do it. And it's abhorrent in part because tribal sovereignty suggests that tribes should be able to do this themselves, but tribes currently don't have parity on the international framework to do so. So a coalition of tribes led primarily by the Pueblo of Acoma helped to advocate for and eventually enact the STOP Act. Like a lot of international law, these agreements that the United States signed into are not self-executing. They require domestic legislation. That was true for the 1970 UNESCO Convention that actually wasn't mandatory under US law until 12 years later when it was finally passed through an act of Congress. The STOP Act is an amendment to that, authorizing the United States to work with tribes in order to facilitate the repatriation of items like the items that were inappropriately being sold in a Parisian auction house that were claimed to be from the Pueblo of Acoma. This was passed in 2022, and so December 2022, so it is very new. The ink is still getting dried. The Department of Homeland Security and the State Department are not accustomed to working with tribes in this kind of way. And so we are actively building new legal pathways, expectations, and norms for how this goes. But what I think is notable is a couple of things. One is the fact that the United States is not doing this, on the behalf of tribes or, paternalistically looking out for them. It is with tribes. And so that's noteworthy because it didn't necessarily have to look like that, but there's been a lot of work to get to that point, which I think is great. But I think it also reflects what I also heard in the Bears Ears presentation by Ms. Hoffmann, is a sense that we all are coming to, I think, better understand what it means to be guests on this land and what it means to form meaningful connections. What does it mean to be here? Is settler colonialism really going to frame our relationship with each other and with this place going forward? Or are we going to try and build some actual forward-looking legal pathways to facilitate that? And the STOP Act, NAGPRA, I think are both examples of starting to do that in a good way. And so I think we're heading in a good direction, but there is a lot of work to do. Thank you.
So we have a lot to wrap our minds around there. We have actions happening at the international level, the national level, private actions in terms of what museums and galleries are doing, private individuals in terms of artists and what they can do. So I would suggest that we take a 10-minute break here. Come back with our next panel to try to unpackage some more of this. And that will give us about 20, 30 minutes of Q&A time so we can get to your questions because I think you're like me, you have a lot of questions for these panelists. So let's do that. Let's come back at about 4:10 and we'll kick off our second panel. Okay, welcome back, everybody. So our second panel starts off here with someone who many in the audience are very familiar with, Professor Cheryl Packwood. Cheryl is a visiting professor here at Albany Law School, where she is an expert on international law and money laundering. She was the overseas representative for the government of Bermuda and director of representative office in Washington, D.C. She was also the CEO and deputy chairman of Business Bermuda, working on trade missions and business development tours. Prior to that, she held senior positions with Digicel Bermuda and Bermuda Monetary Authority. She was also a practicing attorney in Côte d'Ivoire in Africa for 13 years. And we are very fortunate to have her here, kicking things off on the second panel. After Cheryl, we'll have artist Jarrett Key. Jarrett will be joining us via Zoom. Jarrett is an accomplished artist and creative thought leader. They are the co-founder of Codify Art, a collective dedicated to showcasing multidisciplinary works by artists of color, particularly women, queer, and trans artists. Jarrett was named one of Forbes 30 Under 30 for art and style in 2020. They are represented by 1969 Gallery in New York City and have exhibited their work from a 40-foot mural in Norfolk, Connecticut, to Dallas, Texas, over to San Francisco, and back to the fabulous De Cordova Museum in Lincoln, Massachusetts. So thank you for joining us, Jarrett. And last, but by no means least, our venerable Professor Patricia Reyhan. Pat is a professor of law here at Albany Law School. She teaches foundational courses and courses on international law. She has authored numerous articles on international law, property law, and conflicts of law. Her most noted and cited work is called A Chaotic Palette: Conflicts of Law in Litigation Between Original Owners and Good Faith Purchasers of Stolen Art. It appeared in the Duke Law Journal about 20 years ago, and it is a fantastic piece that has held up amazingly well over the last 20 years and is absolutely worth a read as well. Her current scholarship interests are those surrounding the protection of art and cultural property in times of armed conflict. With that, please join me in welcoming our first guest, Professor Cheryl Packwood.
Good afternoon, and thank you, Jonathan, for that. Excuse me, Professor Rosenbloom. I still am coming out of the private sector and everybody's by their first name, so I'm sorry. I want to say that before I start this, it really should be my former student, Marie-Thérèse DeWitt, who should be giving this presentation. And I actually thought about stealing her presentation from my class when she talked about money laundering and art, but I didn't. She won't be able to get me. But art has probably been one of the least discussed topics in the world of money laundering and terrorist financing. I want to provide you with an introduction, a brief introduction, or a brief primer, if you will, on the fundamentals of anti-money laundering, or AML, as we call it in the industry, and counter-terrorist financing. So what is money laundering? Money laundering is the process of integrating proceeds of crime into the legitimate stream of financial commerce by disguising their origin. We've heard a little bit about that, some of that today. The International Monetary Fund, or the IMF, estimates that between 2 and 5% of global GDP, or $1.6 trillion to $4 trillion, is laundered globally on an annual basis. Approximately 300 billion is laundered through the United States, which constitutes approximately 15 to 38% of all money laundering around the globe. In 2020, banks paid out over $10 million in fines globally for money laundering violations. The fundamental importance of combating money laundering goes to major crimes underlying the illegal flows of money and successful mainstreaming of funds in the global financial system. According to reports by the UN Office on Drug and Crime, the U.S. Department of Homeland Security, and the Global Terrorism Database, Mexican drug cartels take in $29 billion from the United States annually. Since 2006, there have been 150,000 drug-related homicides in Mexico. There are an estimated 40 million victims of human trafficking worldwide, of which 10 million are children. Slave labor generates an estimated $150 billion. 3/4 of the terrorist attacks in Europe cost less than $10,000 to fund. In 2017, 26,000 people were killed worldwide in terror attacks. So, how do you money launder? How do you get your money into the mainstream? There are 3 stages of money laundering: placement, layering, and integration. Placement is the process of integrating the money obtained through illegal activities into the global financial system. Layering consists of creating complex layers of multiple financial transactions designed to disguise the audit trail. Integration is the means of using apparently legitimate transactions that allow the funds to be dispersed back to the criminal. So what is terrorist finance? It is a financial crime perpetrated by domestic, foreign, or state-sponsored individuals or organizations that use funds to support the agenda. activities, or causes of terrorists or terrorist organization. The funds raised usually originate from legitimate sources, such as charitable organizations or donations from supporters, as well as criminal sources, such as the drug trade, weapons smuggling, fraud, kidnapping, and extortion, and the antiquities trade. According to the Global Terrorism Index, Measuring and Understanding the Impact of Terrorism 2016, published by the Institute for Economics and Peace, the worst year in terms of human impact was 2014, with 32,765 people killed. Of the more than 250 known terrorist groups, nearly 75% of terrorist attacks have been attributed to ISIL, Boko Haram, Taliban, and Al-Qaeda. Similar to money laundering, the process of terrorist financing takes place in different stages. The stages are collecting the money, storing it, and moving and using it. However, the collecting stage includes and often does legitimate sources of funds. The collecting stage refers to the generation of funds intended for a terrorist or terror organization. The funds can originate from a variety of sources, including direct donations by individuals and organizations, the use of charities and nonprofit organizations, as well as criminal activities. The funds are then stored in a variety of places until needed. It is moved through the traditional banking system as well as through money service businesses. They're called the Hawala financial system. It is smuggled in the form of cash, gold, artwork, or other means, or if they have it now, cryptocurrency. The funds are used for a sundry of different things, including using it for the terrorist organization to pay for weapons, material, equipment, overheads, media and messaging training, and salaries. The money is used to pay for foreign fighters and organized travel services or to cover passport and visa costs. Some of the forms of use are mundane day-to-day expenses, including providing the local population with funds for food, all of which are difficult to identify as terrorism related. Identifying terrorist financing is often made more difficult by the size of the individual transaction. The individual transactions are small. The 9/11 Commission report indicates that the 9/11 plot cost Al-Qaeda approximately $400,000 to $500,000, of which approximately $300,000 was deposited into the US bank accounts of the 19 hijackers. So do the math. In the late 1990s and early 2000s, Al-Qaeda was able to raise about $30 million a year, mostly from zakat and sadaqah, which are charity donations in Islam, from wealthy Arab donors and other supportive Muslims around the world. The money was funneled through Islamic charities, often charitable foundations, as I've said, and backed directly by the Saudi government and through hawalas. And the same methods continue to be used to fund Al-Qaeda and its offshoots today. Combating money laundering and terrorist financing, together with human trafficking and the proliferation of weapons of mass destruction, is a global effort. Many governments, private groups, and multilateral organizations are active in issuing guidance and driving AML compliance efforts, included but not limited to the World Bank, the International Monetary Fund, the OECD, the Organization for Economic Cooperation and Development, the European Commission, OAS, the Organization for American States, Europol, Interpol, the Basel Committee, Egmont Group, Wolfberg's Group, Transparency International, and FATF, the Financial Action Task Force. It is an intergovernmental body established in 1989 on the initiative of the G7 to set standards and promote effective implementation of legal, regulatory, and operational measures for combating money laundering, terrorist financing, and other threats related to the integrity of the international financial system. FATF just came out with its report on money laundering and terrorist financing in the art and antiquities market in February of 2023. and it was really the first dedicated report of its kind. The global trade in art, antiquities, and other cultural objects is a multi-billion-dollar industry. The estimated value of global sales of art and antiquities in 2021 reached 65.1 billion US dollars, increasing by 29% from the previous year. According to the United Nations Office on Drugs and Crime, the underground market for art is as much as 6 billion annually, of which 3 billion is attributed to money laundering and other financial crimes. The FATF report indicated that illicit funds laundered through the market for cultural objects can be derived from various crimes, including corruption, embezzlement, drug trafficking, tax fraud, and other offenses associated with the activities of organized criminal groups. As my colleagues can tell you, art and antiquities markets are diverse in size, business models, and geographic reach. Most are relatively small, and most art dealers and buyers are legitimate. Nevertheless, criminals, including money launderers, take advantage and exploit these markets. And this is due in large part to an industry that deals in anonymity and indeed cash and high amounts of cash. A basic transaction, for example, can involve an arms dealer who needs to get $5 million into the legitimate financial system after he sold weapons to a warlord in Liberia, for example. He buys a painting, sculpture, or other piece of artwork at an auction. Auctions are a main place for buying artwork with cash. He transfers it to a storage facility in a free port, say in New York, Switzerland, England, you name it. He then sells it anonymously without moving it out of storage. He has now obtained money from a legitimate business transaction and deposited these legitimate funds into his bank account, his squirrely bank account. These free ports are estimated to hold over $100 billion worth of artwork, with Geneva and Zurich holding each over $10 billion. It should be noted that some countries have put in place regulations regarding customer due diligence, record keeping, and inventory declarations, such as Switzerland and also Singapore. Of course, paintings and artwork are easily brought into the US and other countries with no declared value or minimal value and then sold to buyers. Bank representatives have done this for their clients, private bankers, and regular travelers do this. Artwork and cultural objects and antiquities can be used as bribes to avoid money transfers and tracing. They can be held in storage as a means to hold value for the criminal, his family, his children, or just because he wants to show it off. With regards to terrorist financing, the antiquities trade in cultural objects comes into play. These pieces are smuggled out of countries such as Iraq and Syria, and more globally, from all over the Middle East, Africa, Central Asia, into places like Lebanon, Iran, Hong Kong, and Turkey through middlemen, and then sold into Europe and America. There is no documentation and regulations, and tracing becomes difficult. Women are often used to transport cultural objects on their persons because they are less likely to be searched coming out of Middle Eastern countries. Also, the terrorist groups such as ISIL will facilitate the excavation, looting, and trafficking of cultural objects, and it will also tax non-members who are digging at different sites that aren't licensed on the objects that are found by the diggers and sold, and they'll tax them as much as 20%. The FATF report, the Financial Action Task Force, the report lists several challenges regarding money laundering and terrorist financing and the industry revolving around art, antiquities, and other cultural objects. These challenges include difficulties in tracing the origin of cultural objects, a history of privacy and a use of third-party intermediaries in the sector, your dealers, your agents that will buy and sell on your behalf and without saying who you are. Inadequate measures or none at all to identify and verify customers, and a low number of suspicious transaction reports filed with the Financial Intelligence Unit. Suspicious transaction reports are reports that are made when either the bank, usually a bank or insurance company or financial institution, is suspicious of the money, where it's coming from, who's depositing the money, who's buying an insurance policy, for what reason, will then send what's called a suspicious transaction report off to the Financial Intelligence Unit of their country or government, or if in a state, you'll have a, New York State will have a Financial Intelligence Unit, for example. With regard to challenges of investigating incidents of money laundering, problems include a lack of prioritization of investigations in this area, limited resources, awareness, and expertise by operational authorities, and difficulties with cross-border investigations. So what can be done? First, it should be noted that there are international conventions which do exist to combat the illegal trade in art and cultural objects dating back to the Hague Convention in 1954 for the protection of cultural property in the event of armed conflict. There's the UNESCO Convention on the means of prohibiting and preventing the illicit import, export, and transfer of cultural property. And then there's that was 1970. And then there's the 1995 UNIDWAT Convention on stolen or illegally exported cultural objects. I'm waiting for, we should have another convention coming like shortly, since they're not really working. But they may tell me otherwise. Anyway, there are even UN Security Council resolutions. They were actually able to agree, which identify the looting and trafficking of cultural objects and terrorist financing, and condemn the looting, smuggling from archaeological sites, museums, libraries, archives, and the like. However, I have to tell you, as a former financial services regulator back in the day, I know all too well that these conventions and resolutions are only as good as the expertise globally to investigate and enforce. Indeed, even FATF recognizes that its own recommendations, FATF has put out 40 recommendations since 1989. Its own recommendations do not designate art dealers and professionals as businesses required to report on suspicious transactions to countries' financial intelligence units. So, in the first instance, in order to curb the use of artwork to launder money and raise money for terrorist organizations, the FATF report that I referred to earlier suggests that countries need to put in place regulations designed at targeting the use of artwork in financial crimes. Specialized units and investigative training programs focused on art, antiquities, and cultural object markets need to be established in the relevant government agencies. Databases and promoted cooperation with experts and archaeologists to help trace, identify, investigate, and repatriate cultural objects need to be developed. Registration requirements, customer due diligence, record-keeping requirements, and suspicious transaction reports need to be put in place in the form of regulations. We need model guidance codes and model guidance codes and codes of ethics, need to be developed as well. And it should be noted that some countries have put in place specialized law enforcement units with specific authority to investigate crimes in the markets for cultural objects, including financial crimes such as fraud, forgery, illegal trafficking, and theft. Italy is an example of one such program. Finally, I want to point out, and this is not money laundering, but that one of the greatest and underreported antiquity transporter thefts took place in Nigeria by the British during the colonization period, during the first part of the 20th century and the latter part of the 19th century. The famous Benin bronzes from the 16th century were taken out of Nigeria by British soldiers in 1897. Nigeria has only received 6 back as of the end of 2022 from the British Museum. I understand that there were over 900 bronzes taken. The Smithsonian Institute in Washington has managed to return 29 bronzes to Nigeria. I learned of all this, of the theft of the Nigerian bronzes, when I was just a teenager, because my parents were avid collectors of African art and textiles. I too became an avid collector. And I remember when I was living in Côte d'Ivoire, I visited a French couple in Abidjan who had a warehouse on their property full of antiquities collected from across the continent of Africa, including these ginormous statues from sub-Saharan Africa. And I want to say cultural objects and masks that were, as they referred to them as active, that they had powers. That's for you to decide whether or not they had powers. I saw a lot of things in Africa when I was living there for 13 years that are not necessarily explainable by natural science. But now you're going to send me off to the loony bin. So I will stop there. Okay. I look back on that cultural theft and I wonder whatever became of that cultural continental heritage. I don't think I will ever know. Art is so easily lost, and in particular, art and antiquities that have not been valued as such because of a fraught historical past and Western judgment of what constitutes art, antiquities, and cultural objects. I remember that the British designated the Benin bronzes as true art as compared to the rest of art in Africa, which was not considered civilized and thus of value. I want to end on a happy note, though. When I was visiting the Indian ambassador in New York, when I was representing Bermuda, there was a large stone relief of Apsara dancers. Those are the dancers that come down from heaven to entertain kings and gods. It was displayed in the front hall of the embassy. The Indian government had just recovered it, and the ambassador beamed with pride and happiness. Thank you.
Thank you, Professor Packwood. Jarrett, can you hear me okay?
Yes, I can. Can you hear me?
Yes, we can. Fantastic.
Amazing. I'm gonna
Hang on
share.
1 second. We just got to all the screen here.
Okay, let's see. Hi, can y'all see my screen? Do y'all need a second?
Oh, just give me 1 second.
Perfect.
I just need you a call, Jarrett, so I think we need to accept it and then I can share.
Oh, say that again. Let's see. Stop sharing screen. I'm gonna try again.
There we go. Sorry, thank you.
And can y'all see my screen?
Yes.
This is so Zoom-like. How y'all doing? My name is Jarrett Key. I'm so happy to be participating in this law symposium with you guys today. I am in Providence, Rhode Island right now. I am an educator and an artist, and I am currently in tech for a play that I'm directing at Brown University. I apologize in advance if the signal cuts out, you know, somehow Brown can't get stable internet at Brown. Feel free to add me on Instagram if you want to follow me after this or look at my website. I'm going to start with, first of all, just saying, you know, I'm an artist. A lot of the work that I do is about making art and selling art and sharing my stories and narratives with spectators, with audiences around the world. So a lot of the conversation today has been focused on sort of institutional or national or federal laws and policies. And I'm gonna sort of shift gears a little bit and talk about what does it mean to be an artist working today? What laws, policies, and ideas affect us and transactions that we need to make money to sell our work. But first, I'm going to share a little bit of my work and tell you a little bit about myself, and then we'll jump right in. So I am an interdisciplinary artist. So that means that my practice involves various kinds of medium working together to create a fluid image or object. So in the video you just saw, that is an installation where I paint with my hair. I grew up in Seal, Alabama, and my grandmother always said, your hair is your strength. Don't cut your hair. That's actually from the Bible. It's from Samson Delilah's story. And growing up, I never knew what that meant. My hair is my strength. My hair is my strength. And then when I left undergrad and I went to New York City, I was like, let me try not cutting my hair. And I realized that my hair reminds me and grounds me who I am, and it connects me to everyone that came before me. So I began to make these abstract paintings that became these embodied works of me transcribing gestures onto canvas to create language. My grandmother was illiterate. She couldn't read. So I thought a lot about, and I think a lot about, like, how do I tell stories that don't require high levels of literacy, that could depend instead on an embodied or cultural understanding of an object or a mark or a gesture or even an image or color. And so I do kind of performance work, and I also am a painter. And so maybe some of you are familiar with like Renaissance Italian frescoes. And so I actually make frescoes with cement, and I call them my urban frescoes. So while the cement is wet, I add material to this wet cement and create an image and create scaffolding and surfaces in order to evoke those images. They're often about Black folks that I know in leisure, trying to be free. That's my big question in my work is, how do I show the freest Black person that I can show? Oftentimes that looks like them flying in the sky. If gravity can hold you down, then what can? There actually is a long history in Black culture and Black folklore in America about Black people flying. And so this work, my work, is in complete response and legacy to that. And so yeah, here's some more of my work. So a part of my process as an artist, is working with other people. So I started an art collective many years ago called Codified Art, and we're a multidisciplinary art collective. And we focus on producing, showing, curating, and creating space for artists of color, queer artists of color, and trans artists of color. And I'm just bringing this up now because, later I'm going to talk about what can we do as a community to support artists, and supporting collectives, working with your community to support artists is one effective way. So now to jump in to what we're going to talk about today. I just wanted to start with some basic jargon. I feel like today a lot of people have been talking about a lot of stuff, right? Oh, so a collector, a gallery, what's a market, a primary market, an auction house. So I just wanted to demystify what those words mean for me and how they show up in my own reality as an artist. So collectors are those people that buy work. You can be a collector. If you've ever gone to a coffee shop and you said, oh my gosh, I just love that painting on the wall. How much is it? 25 bucks, I would love to buy that. You are an art collector. Art collectors buy both original work, and they also buy copies of work, as we've been hearing about today. The work can hopefully the work has a provenance, right? A history of selling, a history that says it belongs to someone before they purchase it, to make sure that it's not fraudulent. But collectors are the people that buy work. Galleries are places, as an artist, a gallery is where I want my work to be seen. It's a place to show work. And that's true, but a gallery is also a store. I think about a gallery almost like a luxury store. It's a place where if I have a couple of $1,000s or more, I can purchase something. It's not just for show. So if you're passing a gallery on the street or in your community or in your city or in your state, you're more than likely able to buy things from that gallery. Gallery works with artists. And like me, artists are often represented by galleries. So what does that mean? If I'm a gallery, I can say, let's say I want to show an artist's work and I really like this artist's work. Cool. I can approach this artist and say, hey, I really want to work with you to sell your work. I want to work with you to show your work. I want to provide opportunities for you to sell your work. Would you like to be represented by me? Traditionally, represented artists have had a contract. So I say, yes, I agree. I would love for you to work with me to sell my art. And we stipulate what that looks like, what that agreement looks like, and we sign a document, a contract. However, in contemporary art world, many people are not signing contracts with their galleries anymore. I know that I didn't. Me and my gallery have almost a handshake relationship contract with each other. I assume goodwill on their part and they assume goodwill on my part. However, even with that goodwill comes these transactions, right? When we're selling work as an artist, it's really important for me to have a contract that stipulates the objects that this gallery is able to sell, the works that this gallery is able to sell, how long they have to sell that work by, and how much that work is worth. And there's also stipulations if the work gets damaged, if the work needs to be shipped, and if the work is sold. These are called consignment agreements. These contracts are really the most important thing for artists when they are trying to work with a gallery. Oftentimes when artists don't have strong consignment agreements with galleries, they get taken advantage of. Because suddenly a gallery, if you don't have a consignment agreement, can say, oh, I'm gonna sell your work whenever I want. I don't ever have to return your work to you. Actually, I decided that I sold this work and therefore I'm not gonna give you any of the profits for that work, right? That is one that's possible and it's happened many, many times. I know that I have been in situations where I've had to call lawyers, for example, to review my consignment agreements if I'm sending them to galleries to make sure that they're tight, to make sure that I'm not vulnerable to any kind of loopholes or manipulations or being taken advantage of. Now, outside of the gallery space, there's things called commissions. I, as an artist, have a skill set that I can sell. I'm a painter. I can sell that skill. If you, as a collector, are interested in buying one of my paintings, but you maybe don't like the paintings that I've already made, you can commission me to create a new painting based off of a conversation that we have. An artist and a collector will agree what the commission is, what the parameters of that commission is, and we sign a contract. And once I complete my skill, once I complete my job, the commissioner pays me and everyone is happy. Now we've been talking about selling and buying and selling and buying, but in the art market, there's actually kind of two separate ways to think about selling art objects. One is the primary market and one is the secondary market, which we're going to talk a little bit more about, and one is royalties. So primary art market. So an artwork or a capital that is sold for the first time in a gallery or directly from an artist. So if I'm putting up an original work and I'm going into a gallery, I'll say, this is my work. I can prove that this is my work. I have signed the back of it. I have a certificate of authenticity. Can you sell my work? And the gallery is like, yes, we can sell your work. Here you go. We're going to sell this work. And then we will come up with our consignment agreement and decide how much money I receive for when they sell the work and how much money they receive. Oftentimes in these consignment agreements, artists receive 50% of the profits for selling the work and galleries receive 50% of the work, which honestly feels like a really steep relationship. If I'm making this work and I give my work to you and you sell it, how do you get half of the money for this value of this work? Well, artists have decided I can't sell, personally, Jarrett Key, I can't sell $10,000. I can't sell a $10,000 work in my studio, but this gallery can sell a $10,000 work in their store. That is a benefit for me. So I am willing to give $5,000 to this gallery so that I can ensure that this work gets sold. However, what happens when, after I've sold a piece through a gallery in a primary art market to a collector, and now this collector has my work and they want to resell it? This is called the secondary art market. The secondary art market, I feel like, honestly, for most working visual artists in particular, is the bane of our existence. People are often buying our work and then going off months later, years later, and selling them often for a lot more than what we made when we sold them initially. A reselling of artwork can happen at an auction house. For example, we talked about auction houses. So for example, Sotheby's or Christie's, oftentimes when work is sold in those spaces, that work already has a value associated to it because of this primary art market sale, and now has been reevaluated for a different price in these auction houses. A secondary art market could also be a gallery, can also be Artsy, can also, maybe you'll heard of Artsy, the website that showcases art around the world, or it can be sold from a collector or institution. So when people sell our work and they make more money from it, what happens? Oftentimes, artists don't receive royalties from those transactions. And to be clear, a royalty provides an artist with a fee of the increased value of their work at a percentage based off of whatever new proceeds happen. Currently, in the United States, there is only one state where there are royalty resale protections. And that state, well, actually, that state was California, but the law actually recently changed a few years ago. Around the world, there's 70 countries that actually protect the resale value and royalty values of for artists if their work gets resold. Now, there's actually a lot of conversations around this. I'm sure you've seen, like, Carrie James Marshall sold a piece for $116 million at Sotheby's at an auction. That's so cool. Great for Carrie James Marshall, but he doesn't see any of that money. So there have been these important tech innovations recently that are trying to protect artists and their royalties for down the line. So if work is resold in the secondary market, artists can have some claims to those proceeds. A couple of those tech platforms are called Fairchain or called ATO. And they really work through blockchains and tracking and digital contracts and digital online provenances to try to maintain a clear tracking of what's going on with this work. Where is this work going? Because currently, you can buy my work and I don't have to hear from you again. And so you can go off and sell my work and I might not even know that my work is being sold. Why is that problematic? Why is it problematic for someone to sell your work without telling you? Well, suddenly, if I'm an artist and I've sold my work for, say, $5,000, and 2 years later, the work that I'm still selling in the primary market is selling, let's say, maybe for $6,000, you know, I can control that. But if someone wants then to take my work and it goes to an auction, and someone in the auction decides that my work is worth $30,000, that messes up my ability to sell my work for $6,000. Can I consistently sell now all of my work for $30,000? Has the value of all of my work gone up to $30,000? Or is that just one piece? These become really problematic for an artist because suddenly now everyone is expecting to buy my work for $30,000 and no one can afford it. I was potentially lucky to sell that one piece for $30,000. And my market can't reflect and can't hold up a transaction that high. So artists really need a lot of protection to make sure that people aren't overinflating the value of their work. I just wanted to briefly talk through this slide. It's a little bit of a history about art royalties in America. I stole this slide from ATO platform in a presentation that they gave to me a few years ago. And I just thought it was just such a succinct way to talk about this history. So there is a famous artist in 1975, let's go back, in 1975 that sold a work for $900, and it was later sold for $85,000. And this artist, Rosenbloom, was like, this doesn't work. I can't have a living if someone is selling my work for an exorbitant amount more money than I'm making from it initially. And I have no access to that money. So California, a few years later, created a Resale Royalty Act that didn't last very long. Then the UK and the EU proceed to actually create royalty laws and royalty right laws for artists, but they're not enforceable internationally. They're not necessarily even enforceable across their own national borders. And then in 2018, the Supreme Court said, and this is based off of like understanding of a copyright law from 1977, said, actually, all of the artist resale rights are no longer available to artists in America. And then in 2021, we had NFTs arise, and then in 2022, we have more things, and we're really just in this particular space right now as artists where we're trying to figure out how do we maintain some access and control to a shifting market and shifting value of our work. So, what can we do now? You know what I mean? What can we do now? As a community, our job, we can all be collectors. We can all support local artists. We can all collect work. And if you're collecting work, you can tell your artist, I will not resell your work. And if I do resell your work, I will make sure that you and I are in conversation with it. And we have already contracted how much money you will get from me if this work goes on sale at a specific percentage. You should also go and support local institutional shows. Add artists on Instagram, bless their work, share their work, comment, like. And then, and I think finally include artists in discourses and dialogues like this. Our artists are often the people that hold our history. History is the story we tell ourselves about ourselves. And artists are often essential to remembering those histories. So how do we continue to keep us included, protect us from being taken advantage of, and make sure that if the value of our work does change, that we have a piece of that pie? I'm sure that we all together can also brainstorm legally, policy-wise, in our community, other things that we can do to show up for artists. But for now, I sort of just wanted to leave you with that. And let me know if you have any questions. Feel free to add me on Instagram and follow me on my website. Thank you so much.
Thank you, Jarrett. You gave some contract professors in the room a little bit of heart palpitation there for a moment with the non-signing of the contract, but I think we're good.
I volunteered to go last. One, so it'd give me more time to ruminate on what I wanted to talk about, but I realize I am in going last, the one thing standing between the question and answers and then the reception afterwards. So I will try very hard to respect the time limits, although those of you who know me know it's not in my nature. Professor Rosenbloom, thank you for the introduction. I have been recently introduced as venerable, and it makes me think I'm becoming my own cultural patrimony or matrimony of this law school at this point. But I appreciate the invitation and I appreciate the invitation to speak here. My remarks will be directed in a slightly different way. My subject will be a slightly different one. I did my early work in this area on issues of looted and stolen art and the tension between the original owners of that art and the ultimate buyers of that art who were at different stages of good faith and who between two relative innocents who should win. But it struck me, and in doing that, certainly I looked at a lot of looting of art that took place during armed conflict. The most recent large one being World War II, where not just Nazis stole art, Soviet armies stole art, American soldiers stole art. It was a quite wide group of people who were engaged in the looting of art, and the decades it took for that art to bubble up. One of the things I thought was so interesting, Leila, in your comments, was this notion, if you think back to some of the cases she was describing, the cases arose out of the presentation of works of art at galleries. The public and people going to galleries and people looking at the advertisement for exhibits and saying, whoa, wait a minute, what is that? And that created a really interesting problem in the development of the law of rights to property, in that we have to be careful as we construct legal rules, not to create rules that will result in art not being shared for fear of the fact that somebody's going to make a claim on it. Art not being shared by people who in all good faith bought it. So particularly today, when we have multi-billionaires who can buy incredible works of art and never show them anywhere, and certainly that is happening, we need in a large way to have a discussion about the way in which our rules incline people to keep their holding of art, if they have any question about it, or even if they don't, to keep it secret. Same with mentioned colonizers, and Lauren, you talked about that as well. Belgium, the Dutch, England, the French, the Spanish, the Americans, and the taking of works as part of colonization, deeming certain works art, situation, and other works not art. But one of the things that struck me as I moved through my progression of thinking about all of this is that if art is looted, it still exists. It someday, hopefully, will bubble up. If art is destroyed, it no longer exists. And so I started turning my attention toward the destruction of art rather than the looting of art during the time of armed conflict. And just before I get to that, Hillary, you mentioned something that was so interesting to me as a property professor, and I have some of my property students in the room, this notion of needing to use something or employ something or utilizing something as the only justified notion of a cultural heritage. That is, leaving something in place, honoring something in place. How can that be sort of part of our cultural heritage? And how can we even conceive of looting that? And that is such a Western sort of utilitarian view of cultural heritage, isn't it? It's interesting. I was so interested in your comment about how do you bring back the things that were looted from the Bears Ears area when you don't have a place to protect them? And we all know that that's been a great explanation of the British Museum, is that if it weren't for the taking of the Elgin marbles by Lord Elgin, the Elgin marbles would have been destroyed. And you hear a lot of that explanation from museums as well, the British Museum in particular. Without us, they wouldn't exist at all. And the not existing at all is something we have to think about. So I want to read you two quick things. For whatever cause a country is ravaged, we ought to spare those edifices which do honor to human society and do not contribute to increase the enemy's strength, such as temples, tombs, public buildings, and all works of remarkable beauty. What advantage is obtained by destroying them? It is declaring oneself an enemy to mankind, thus wantonly to deprive them of these monuments of art and models of taste. That's the first quote. Second quote, today's trial is indeed historic, and it is all the more historic in view of the destructive rage that marks our times. in which humanity's common heritage is subject to repeated and planned ravages by individuals and groups whose goal is to eradicate any representation of a world that differs from theirs by eliminating the physical manifestations that are at the heart of communities. And Jarrett and Lauren, I think of you as I read those language. The difference in values of these communities are thus simply denied and annihilated. This is the essence, the very heart of this case. What makes this crime so serious is the fact that it is a profound attack on the identity, the memory, and therefore the future of entire populations. This is a crime against that which constitutes the richness of whole communities. The first quote is from 1797, the Law of Nations. The last quote is from the only so far successful single focused criminal trial that focused only on the war crime of destruction of cultural property. So we have a pretty big spread between 2017 and 1797. So 1797, we start to see a recognition that destroying art, destroying culture is not just harming your enemy who you conquered, but harming yourself, harming your own polity, and harming the world. That being said, for at least 2,000 years and probably longer, the destruction of cultural property, the destruction of cultural identity was not a byproduct of armed conflict. It was an intention of armed conflict on the part of the person who was the victor. It wasn't enough to win the war. To win the war, you truly had to wipe out, not physically, yes, but not completely physically, culturally wipe out the vanquished. And you would do that in any number of ways, but including wiping out their cultural monuments, wiping out their libraries, wiping out their language, wiping out their schools, wiping out their artistic creations. It was all part of what we now call the erasure that came about as part of armed conflict. And this continued not just 2,000 years ago and before, through the Roman Empire, the Byzantine Empire, the Ottoman Empire, through, in fact, the Reformation in Europe, in which those in power sought to erase that which they didn't agree with, politically, theologically, artistically, what is art, what is not art, and that sort of thing. So this kind of intentional erasure is not an ancient thing. It's quite a modern thing as well. And as we're going to see, we only have to look to events today to see that it is still taking place. So we had years then of this behavior of erasure, of intentionally wiping out cultural heritage, not looting it, destroying it for the purposes of destroying the spirit of the people whose culture it was. Lauren, I think of your remarks as I say that, and Jarrett, of yours. I could, all of us could, if we had enough time, do so much more than we are able to do. So I will not, walk you through the different steps by which the scholarly comment on maybe it's not a great idea for all of us to be destroying as a natural act of warfare, to be destroying culture, through the steps where we try to recognize that perhaps some protection of cultural heritage, of cultural monuments, of museums, was an attractive thing to be part of the law of war. And interesting, where that really started was the Lieber Code, a code adopted by the Union Army in the American Civil War as guides for conduct of Union American soldiers. And that was the first place where you saw a codification of this notion of not destroying cultural property. So the Lieber Code speaks particularly about the need to protect cultural heritage, classical works of art, libraries, scientific collections, or precious instruments, all from all avoidable injury. The interesting thing about that rule, if you will, that standard in the Lieber Code, which was followed in different ways through different international acts, is until very recently, it was all subject to the whim of military necessity. You can't do this, you cannot destroy this unless it is militarily necessary to do that. So that the attacker would argue if the target of the attack were a cultural monument, were a library, would argue that the military forces of the other side were housing themselves in those places. And sometimes that was true. And in fact, one of the modern things that's happened with the law in this area is to make it illegal, in fact, to hide military forces or military material within cultural sites for exactly this reason. But we had this overarching notion of military necessity. And if it was military necessity, do what you will, regardless of the cost to cultural heritage, to cultural monuments, and that sort of thing. Professor Packwood, I believe, mentioned the 1954 Hague Convention. That was the big one that changed it. If I want to feel like an artifact, I was alive in 1954. It's always kind of stunning when someone says, wow, and then it's a time when you were alive. But the 1954 convention was the first place where one could say that the international community got serious about the protection of cultural property. It recognized that damage to cultural property belonging to any people whatsoever means damage to the cultural heritage of all mankind, since each people makes its contribution to the culture of the world. It was a convention on the protection of cultural property. It too, though, had, I should mention one other thing about that convention that was really, really important. It was one of the first times that first event where we recognized not just the negative obligation of not destroying cultural property, but the positive obligation of safeguarding. I want you to think, for example, of the Second Gulf War, when the United States forces went into Iraq, the very quick fall of Saddam Hussein's regime. And one of the most immediate things that happened, for which the United States was appropriately criticized under international law, is we did not station soldiers around the major museums in Baghdad and around other sites, with the result that there was a tremendous loss during that time. But that notion of safeguarding came from the 1954 convention, and a notion that started then and continued in other international conventions of stating to the, if you think of the target country, of stating to a country, you identify, you safeguard. If you know force is coming towards you, you hang the flag of cultural significance, literally a blue flag, on items that are valued by you. So the 54 convention is, we have a bunch of other things we could talk about it and we won't. And then we get to 1999. And 1999, other than my final point, is going to be the last significant year we talk about. In 1999 represents the end of the 8-year Balkan tearing itself, in the former Yugoslavia, just tearing itself apart. And in the process of tearing itself apart, the intentional targeting of religious iconography, religious sites, and that sort of thing. It was the worst intentional destruction of cultural heritage since World War II. And it was horrible, but it got the attention of the international community, so that in 1999, they passed a protocol which invites states parties, insists that states parties to the protocol, in fact, criminalize, and as a matter of universal jurisdiction, try anyone that's found on your territory who has engaged in a level of intentional destruction of cultural heritage within your country or any other country. A huge, huge step. Problem is, not every country signed on to it, including the United States, including Iraq, including Syria, including China. So it's not binding in that way on those countries. Whether it's had a lot of effect or not is questionable. The final thing I'm going to talk to you about is the case I read to you from a moment ago. Mali has signed this protocol, and yet one of the most recent intentional, horrible destructions of culture happened in Timbuktu in Mali. And we have an international criminal court case that resulted in a plea of guilty, a prison sentence, and a monetary penalty against an individual, not during an international armed conflict, but during a religious sort of struggle, if you will, war within Mali. And we could overwrite what happened in Mali, in Sudan right now, in all kinds of, particularly of Northern African countries. The defendant in that case, at the direction of the Al-Qaeda and the Maghreb group he was affiliated with, the defendant in that case was ordered to destroy a number of temples and monuments in Timbuktu for two purposes. It was found to be religious idolatry. It offended the religion of the actors, and it was designed to defeat the spirit of the people for whom those monuments were important to their lives, to their souls, to their generations. We could say the same thing if we had time about ISIS and particularly about the Taliban. You all remember the destruction, I hope, of the Buddhist statues. Never will be replaced. The destruction of many periods in, or many monuments in Palmyra. And one of the things that strikes me in this, and Cheryl, this gets back to your point as well, Professor Packwood, is that what we're seeing now is the destruction of cultural property that's happening in areas that are already falling apart anyway, where there are failed states, where there is no centralized government. This is the problem in Mali. Even though they signed the protocol, they don't have the political power to do anything about it. I have been teaching international law since 1980. When you teach international law, as all of us in some ways have, you have to have hope, and you have to have spirit, and mostly you have to have a really long lens. So we can focus in on how awful Mali was, how awful the destruction of Timbuktu was. We can also focus in on the fact that there was a prosecution and that it was successful, and that gentleman spent time in jail. He was released early, but he spent time in jail, and maybe, just maybe, that will start to change things. My own belief, and my final thought is it's probably not going to change until a lot of other things change. When Professor Packwood was talking about trafficking in children, in sex slavery, you listen to that and you think, wait, should I be that concerned about cultural heritage? Is culture more important than that? On Abraham Maslow's hierarchy, is culture more important? And the argument has to be, it is at least as important, because it has to do with the soul of a people. And if you destroy the soul of a people, intentionally to destroy the soul of a people, that has to be something with which the international community is concerned. Thank you for listening.
Thank you, Professor Reyhan. So we have some time here for questions from the audience. Yeah, sure. We have a microphone so that people on the Zoom can hear as well. And Jarrett and Lauren, if you want to weigh in, please just, why don't you just jump on in and we'll get you into the queue as well.
Hi, I'm Will Matthews. I'm a student here at the law school. I was just wondering, hearing Professor Reyhan speak about destruction of cultural property, I was wondering is there a point at which a cultural body is allowed to destroy its property if it wants to? And where do we draw that line? My mind is drawn to instances that are looked poorly upon in history, like the destruction regarding like the communist revolution in China of cultural property, but also instances where there's a lot more positivity toward it, like the destruction of Civil War statues for Southern generals. I'm just wondering if you have any thoughts on that, anyone? Thank you for the wonderful presentation, by the way.
So that's a great question, and it actually came up in my work fairly recently with respect to a couple of the tribes in the coalition. And it's not quite the same thing as your question, which is the intentional destruction, but it's the allowing of a natural process to continue without doing what Western archaeologists would call like restoration work. So for some of the tribes that I work with, there is a natural process of like ancestral dwellings being allowed to degrade over time, and that's part of their life story. And according to their cultural norms, that should be allowed to happen. And there should not be people out there with, cement and, bringing in these foreign substances to sort of restore these ancestral dwellings. So it's not quite the same thing, but it gets to the heart of your question, I think, which is that value assessment about what happens to cultural patrimony according to the culture from which it originates.
It is a super question, and I've thought a lot about the issue, both with respect to Russia and with respect to the southern part of the United States, the former Confederate states. And as that, and it was in the news, as the pressure was coming to rename army bases, the pressure was coming to take down statuary and that sort of thing. That the argument by many people in the South was this is part of our cultural history. And then the argument on the other side, which I think is an interesting one, and maybe the answer to the question of what happens when a country says, we can use Germany for this, right? That Germany went and intentionally destroyed many of the sites from the Nazi period, intentionally destroyed them. Didn't want the reminder of history to be there for them. That at some point, maybe the answer is you destroy it if that's your answer. In other words, maybe the common heritage of mankind doesn't overcome the heritage of the person whose culture it is. But the possibility, at least, of keeping it in a museum and of the help of the international community in helping you keep it in a museum is perhaps the answer to that. Hillary, when you said the tribes aren't sure they want the things back because they're not sure they have the facilities to protect them is an example of that. It's a great question.
I just want to weigh in on that one because the statutes are particularly insulting to our Black American population. And they were put up as part of to intimidate and oppress Black people in the South. And they were left up, and they have been left. They needed to come down. Now they can go into a museum on our history or whatever, but those pieces of work had to come down. I don't know that they were destroyed. Some of them, maybe the population pushed over, if I recall, but others were taken down. So that I just want to be very categoric on that one.
Jonathan, could I speak to that as well?
Absolutely. And we'll turn it over to you.
Sure. So that is such a great question. And it's one that my mind was going to all different places when you asked it. So one of the things that Lauren mentioned during her presentation is that the United States has bilateral agreements with a number of foreign countries. And one of those is China. And this has often come up in the meetings for these bilateral agreements held by the Cultural Property Advisory Committee, that there are many people against entering, and many people in the heritage sector against entering into these agreements with China because there has been destruction of Chinese culture under the Communist Party. So I know that at least within the US and looking to these agreements, it comes up in terms of, so you're asking about destruction, but it also is related to this issue of looting and the protection and this collaboration between the United States and China and other foreign countries and how they regulate and protect their own property. And there's so many things I could say, but one other thing I wanted to mention, it also reminds me of a main issue in art, which I think Jarrett, this might resonate with him, is the value of art as propaganda as well, and how that art historically has been created and also destroyed as a form of propaganda. And I think it's just such a great question, though, and I wish we had more time to maybe talk about it for half an hour.
Introduce yourself.
Sure. My name is Erica Powers, and I taught ADR last year, and some of my students are here. I'm a lawyer and a former chair of the ABA section of state and local government law. And so I have quite a lot of experience with the removal of statues in the South, because some of my colleagues had to be responsible for the underlying legal justification for doing it. And I also lived in Atlanta for a year. I was the head zoning lawyer for the city of Atlanta. And so I was very interested when Atlanta tried to figure out what to do with their statues. And there was a commission. And some people on the commission decided that when the statues were moved, that there had to be a history of why they were put up and what was wrong with them that was to be placed beside the statues. It's a good question. I think of places like Masada, where a whole culture chose to commit suicide rather than be subjugated by the Romans. But I just want to reinforce what Professor Packwood said, because the intimidating element of having to go to court in Louisiana, for example, and having to walk under a Jim Crow put up statue of Confederate supremacy was intimidating beyond belief. Now, a couple of things that I'll share with you, and then I'll give this up.
Sorry, it's not another question.
Sure. One is that I grew up in Lowell, Massachusetts. There was an area of Lowell called Belvedere, which was named for an estate that was built by Benjamin Butler, who was a Union general, and he didn't pay a whole lot of attention to the fact that you weren't supposed to take cultural items. And so his wealth came from coffins full of pillaged silverware, dishes, paintings, and so on that were taken from Southern plantations. The other thing that I think this is an extraordinary program. Congratulations to you for putting this together. It is just amazing. But if you find me afterwards, I will tell you the story of how I worked at the Museum of Fine Arts in Boston immediately after graduating from law school. I was placed there by a law firm. The reason I was placed there was that they had to change law firms because they bought a painting, which, if it was a Raphael, was stolen from Italy. And if it was not a Raphael, a trustee had spent and been reimbursed by the museum $750,000 when that was quite a lot of money in 1971. I would suggest a couple of things to think about. One is there is still a cultural norm in the art world of secrecy and of the pleasure that comes from secrecy and pulling a fast one. And I think I'll leave it at that, except to say that the Indian schools issue is remarkable. And the fact that we currently have Secretary of the Interior who is a Native American is bringing a lot of focus. But God help us if in the next election we don't end up with a Democratic president.
All right, I think we have time for maybe one more question here.
Yeah.
Oh, you're here? Okay, my name is Kimberly Williams, I'll present.
Maybe just so the folks online can hear you as well.
My name is Kimberly Williams. I'm a 2L at Albany Law. My question is, as far as resolutions, in public international law class with Professor Packwood, we talk a lot about consent. Does consent can be addressed as far as anything of these disputes?
Would you mind repeating the question?
Yeah, no problem. So basically what I'm getting at is, can consent in the area of public international law be used to address any of these disputes in the artworks or cultural heritage?
Did you get it that time? So
Yeah.
whether or not consent.
Yeah, well, to the extent
you.
that countries sign the conventions, they are supposed to abide by the terms of the convention. They don't always. And some conventions more than others. And as you know, every country is sovereign, and in many ways, there is it becomes a matter of, are you going to be a role player in the global community, or are you going to be a good citizen and do what you're supposed to do and what you have agreed to do? The other problem is not all the countries have signed these different conventions. And as I made a little quip, are we going to have another convention in a couple of years on the same topic? Because we've already had 3 plus a protocol, because they're not quite working. You need a will, and with that will, you need the countries themselves have to enact legislation. They have to enact regulations. They have to put in place different units that are going to that are armed with the funds and the expertise to handle all the fraud, forgery, theft, looting. And as Professor Reyhan said, you have to look at this with a long view. We're not where we were in Roman times, but we're not where we want to be.
Lauren would like to also weigh in. Your chance. Oh, for some reason we can't hear you, Lauren. I think it might be on our end though, because you look like you're unmuted on your side. Do you know?
While you try to find her, if I may briefly, and when I teach classes, I often ask my students to look out in the world, not to think of laws just existing in this building, which obviously it doesn't, but just look out in the world and see examples of things we're talking about generally, see where life imitates law or where law imitates life. I hope, having listened to this conversation, that you think about the current efforts in this country to make books unavailable in light of what we've been talking about. The current effort to say, let's have these books not be available. Let's have these books be available as a very modern daily example of what we're talking about.
Lauren, give it a shot. Unfortunately, no. No. Sorry, Lauren.
I think this is such a good question, and
Yeah,
it comes up in my work almost weekly, and I don't know if this is what Lauren was going to talk about, but I was thinking about the United Nations Declaration on the Rights of Indigenous Peoples, and one of the tenets of that declaration is free, prior, and informed consent. So when, colonizing governments are dealing with indigenous nations within their boundaries, they're supposed to move in a way that incorporates consent, and yet that still doesn't happen in a lot of cases, and even a lot of the ways that federal law in the United States is set up, especially around like the Antiquities Act and protection of cultural patrimony. It's still very much from this colonizer lens that does not fully incorporate consent. So I just wanted to recognize that it's such a good question, and it's an area that where, like, you all one day maybe will be realizing some of these ideas that we're talking about in symposia like this, and that's one that really does need to be better incorporated.
So I'm not sure if this addresses your question exactly, but it's exactly on point. Mention consent and nations consenting for the ownership of art and the display of art. And I think about how works may have been taken decades ago under problematic circumstances, whether it's colonization, whether it's just theft prior to the enactment of a patrimony law. And how countries have seen their works, nations have seen their works in museums and on display and in collections, and haven't been able to take steps to make a demand for recovery. And is that consent? Actually, waiting that long, is that consent? I mean, things have changed now in the way we look, and we didn't really discuss this today. No one really discussed museums today and the changing acquisition practices in museums and changing ethics involving museums. So now that we're looking at museums and at these spaces in a very different way, where museums are giving more thought to diversity, to representation, to the education, proper education, giving the proper context. And museums are now willingly returning some objects. I'm not saying all museums, and I know the British Museum has come up. But now that museums are making a choice based on ethics, so one of the objects that was spoken about were the Benin bronzes and how 29 went back from the Smithsonian, and the Smithsonian made a public statement saying, we're not doing this because we're legally bound to, but we're doing this because of ethics. So other museums are following in that step. So the fact that countries have made claims in the past, does that quiet their claims, or can they actually make claims based on ethics as well? And the law too. So I don't know if that's exactly what you were asking about, but when you talked about consent, that's what I was thinking of, because this often comes up with clients. When I have clients, whether they're countries or institutions, contact me and ask, well, can we get it back now? It's been in an institution, it's been on public display for so long. Is there anything to do? Or has the fact that it's been on display, does that just imply that we consent? So my 2 cents.
But then it also becomes a matter of whether the nation is going to put in place laws that are going to require the museums to send back the artwork. The museum, in some are national museums and they're public institutions, but at the same time, many are private. And there's a difference between whether the country is going to act on its responsibilities and its obligations under international conventions and put in place these laws, or whether they're going to just let the museums go, oh no, I mean, the British Museum is resisting, frankly, and they're doing it based on legislation, British legislation regarding the British Museum. So and antiquities and what, and protecting them and the wonderful arguments of, well, if it hadn't been for us, these would have been destroyed.
Can I say
Anyway.
one thing? I'm wearing one of my favorite necklaces. It's of the Parthenon. I wear this to conferences because I'm an advocate of returning the Parthenon marbles, and I will not refer to them as the Elgin marbles. I want to correct you on that.
You're right.
So,
Let's continue this discussion over drinks and food. Sounds fabulous. But first, before we do that, let's thank our incredible panelists for what a fascinating and really wonderful discussion. And number two, we must thank the Journal, Daniela, and Natalie for really. For closing remarks.
Yeah, so I just want to say thank you on behalf of the Journal for coming to the symposium today. I think we all learned a lot and we have a lot to discuss with the panelists at the reception. So please go ahead and head down to the East End for that. And thank you again. Let's give. Take it on the phone. I can take it.
Oh, yeah.